All right. Hello and welcome to this presentation on civil rights protections for parents in substance abuse use disorder recovery. I am Scott Trowbridge here from the Children's Bureau, and I have a rather smaller role in facilitating this and helped assemble some of the team members here. And we have Ann Raish from the Disability Rights section of the Civil Rights Division at Department of Justice. We have Carla Carter with the Office of Civil Rights, also here at Health and Human Services. We have Christina Cooper, who is a senior attorney with the American Bar Association, Dr. Nancy Young, Executive Director for the Center for Children and Family Futures, and also the project manager for the National Center for Substance Abuse and Child Welfare. So today, I personally am very excited to hear this presentation, and we're going to learn some from Dr. Young on the opioid epidemic and how it intersects with child welfare, some big picture numbers that I think many might be familiar with, but she has up-to-date information and understands it really well. We're going to hear more about medically assisted treatment for that, and then we spend a lot of the time on how various laws can protect parents and keep families together or reunite families. And then last, we have a list of a collection of resources you're going to be able to take with you that will be helpful in this. So with that, I'm going to turn it over to Dr. Young.
All right. Let me start with, let's see, do we have the PowerPoint up? Okay, great. Let me start with just an acknowledgement of the National Center on Substance Abuse and Child Welfare. We're actually in our 19th year. We're co-funded by SAMHSA and Children's Bureau, and have lots of resources that are available. So if the data that I present today are interesting to you, you'd like to have your own state data, if you don't have access to that, we're happy to make those available to you, or to make sure that you have resources specific to children of parents with substance use disorders in the child welfare system. On the next slide, I think, is the agenda, which Scott went over already just a bit. So we'll talk about those topics, and let's get started with some broad data. On the next slide, actually two down, Scott, the current data from CDC on opioid overdose deaths, and these are specific to opioids, of the 500,000 who have died in the last decade. When we look at the overall for all overdoses, it's basically a person in America every 10.7 minutes, 840,000. And I think what's partially important in this slide are these eras that we've had of prescription opioids in the 90s, transitioning to heroin in the 2010s, and now the synthetic opioids that I'm sure you're familiar with in your practice, and in overdose deaths as they contribute to multiple substances, including methamphetamine and the synthetics, contributing to the ongoing overdose deaths. And that becomes important because of some studies that the Assistant Secretary for Planning and Evaluation did that we'll mention in just a bit. On the next slide, I'd love to hear from you if this is your reality in your community. What this says is that the prevalence of parental alcohol or drug use as a factor in a case, or more currently it says identified condition of removal in the United States. 2019 are the most recent data that we have available, but it says that just under 40% of children who are placed in out-of-home care have a parent with an alcohol or drug issue as one of the factors in the removal. So let us know in the chat, does that meet with your, even face validity? Is that what your experience is in your communities? Less than half of the children, about 40% of kids, that this is a factor in the case. So while we see that continuing to increase, we also know that when we look at those data by state on the next slide, you can see this variation. The reason why it says it's 40%, and when we talk to practitioners, attorneys, judges in particular, they say, you know, it's more like 3/4 of my case. Sometimes judges will tell us it's basically all the cases that I see somewhere. We find that this is a factor. So all the states are listed across the bottom of the screen, and you see the big variation by state. So we don't really think this is a prevalence issue that varies so much from state to state. My example I used frequently is not to pick on New Hampshire and Maine that have vastly different prevalence rates, Maine over 70%, or Oregon and California, the very different rates in those two places. But the reason I point that out is because it contributes to that overall average of 40% of kids who are removed. So we know that that's probably a reporting issue. And if in your own state you see that what is being reported to the federal government is less than 10% of cases, I think it's a little difficult to make the case that you need resources for treatment for parents when you're not reporting, or your state rather is not reporting on the prevalence of substance use disorders among parents. On the next slide is one of those troubling statistics that, again, I'm sure you're all very familiar with. What this says is in 2019, there were almost 50,000, 47,000 infants or children under the age of 1 who were placed in out-of-home care. That percentage increase has continued to go up over that same time period that we've been documenting the increase in prevalence. So you see the percentage of infants removed on the next slide. Again, an upward trend that about 20% of children removed are infants, which increases that factor of how many kids are in the child welfare system in out-of-home care that are under the age of 6. And when we look at, even with that undercount of the prevalence rate that we saw because of the overall average, when we look at those data by age on the next slide, you can see that if the child was under 1, doesn't look like that one's there. So if the child was under 1, it's about 50% of infants have that box checked in the data system that says parent, alcohol, or drugs. So we know that there's a higher percentage in many jurisdictions of infants who are coming into out-of-home care, and often that's related to identification of prenatal substance exposure. Again, that comes back around as we think about the civil rights protections for parents in recovery, and what does that mean when infants are identified at the time of birth and have a requirement that there is a plan of safe care put in place for them as specified in the Child Abuse Prevention and Treatment Act. Now, if we go to the next slide, we'll talk about the Assistant Secretary for Planning and Evaluation. This study came out a few years ago, but they looked specifically at the county level at overdose rates, hospitalizations, and entrance and other child welfare data. So and also asked many social workers about their experience about substance use in child welfare. You see that what they found on the next slide is that if the community had a 10% above the median in the country of overdose deaths, so in that particular county, we found that it was related to an increase in child reports of maltreatment, substantiated reports, as well as foster care entries. So those overdose death rates become important because that may very well be what you're experiencing in your community. So again, counties with a higher overdose death and drug hospitalizations had higher child welfare case rates. And those substance use indicators correlated with the more complex and severe, if you will, further into the system in the caseloads. As cases became moved from report to substantiation to placement, the relationship with substance use was increased. So I hope that those are reflective of what you're experiencing in your community. And if that's not, we'd love to hear from you and see if we can help untangle some of those data that might be helpful to you as you're advocating for parents and as you're looking at the impacts on children. So Scott, let me turn things back. Oh, let me see one more slide. I think things got a little bit out of order a little bit. So let me go through just this basic data about medication-assisted treatment. We're talking about that primarily as we think about pregnant women and infants who are identified with opioid or other substance use at the time of birth, meaning that they are going through a withdrawal syndrome. We know that medication-assisted treatment during pregnancy increases the engagement in prenatal care. It is the recommendation from the American College of Obstetrics and Gynecology, as well as the Addiction Society, the American Society for Addiction Medicine. We also know that there's a pretty big gap in trying to get access to services. More recently, in the last few years, there's been major increases in the Substance Abuse Prevention and Treatment Block Grant to expand access to services. But also women have historically have been less likely to seek treatment. And they have a different risk profile. So gender-specific treatment becomes very important. And access in rural communities to medication-assisted treatment is even a bigger gap. So again, information on the block grant expansions that have happened in the last couple of years, major resources that have gone into states for substance use treatment. And now I'll turn things back over to Scott about that case vignette.
So now we're going to have a little bit of a quiz, and let me read you the case vignette that's based on. So a client on your caseload started medically assisted treatment near the end of her pregnancy. She's not been participating in prenatal care for 2 reasons. 1, the fear of discovery of her opioid use, and 2, not having access to insurance until recently when CPS assisted her in navigating through the healthcare system. The client mother previously had an open CPS case due to allegations involving an older child, and the case was closed due to family support in the home. So if you can go over to the polls, I'm going to open one, and you should be seeing that. And if people could go ahead and start reading that, and I'll read it too, because I know there's a little delay in the platform. But the question is there a set amount of time that your client should receive medically assisted treatment? First answer is, I'll double check with her doctor, but it seems reasonable she might be able to stop now. She is a success story. Second one is, check her medical documentation and prepare to argue with CPS on this point. And last, recommend that the parent switch medications. I see some votes coming in. Twelve votes. 23 votes. Okay, and if everybody else can see that, we're seeing that most people are selecting here, check her medical documentation and prepare to argue with CPS on this point. So Nancy, what would you say this poll is based on? Is this something you see in your work?
So we do see that there is a common misconception that medication-assisted treatment is not appropriate during pregnancy, but that's actually exactly opposite of, and I already kind of gave you that hint, that ASAM and ACOG put out a statement a few years ago recommending that pregnant women do receive medication-assisted treatment, either methadone or buprenorphine, that is the appropriate treatment. It's always a consideration in any medical care about the risk and the benefits, but we know that the best treatment for a healthy infant and for the pregnant person, the pregnant woman, is medication-assisted treatment. We know that it reduces overdose deaths. We know that it prevents or that it helps to keep the person engaged in treatment. We also know more recently that opioid withdrawal syndrome occurs in about a quarter of infants. So that's not necessarily the determination of what happens for that particular infant developmentally. And part of that statement by ASAM and ACOG says that withdrawal symptoms for a person who has been maintained on medications during pregnancy for that infant is an expected and treatable condition. And if we can kind of shift our understanding to expected and treatable, I think it would make a big difference in how women get access to services and what happens to their infants after birth.
Thank you. So one other vignette. Common misconception is that medically assisted treatment is not an appropriate treatment approach for pregnant and parenting women with opioid use disorders because of the potential adverse effects it may have on the developing fetus or infant. However, medically assisted treatment has been identified as the best option for healthy fetal development because it is proven to help the mother engage and adhere to treatment, reduce the risk of relapse, reduce the risk of overdose death, and reduce the risk of contracting associated infectious diseases such as HIV. And I just realized I wasn't supposed to read that. I was supposed to read this one. Your client has been doing well in his medically assisted treatment program, as well as attending all supervised visitations. He's the non-custodial parent, and the mother is in prison for substantiated physical abuse. There were no maltreatment allegations against the father. The child has been in foster care for 6 months. The father began medically assisted treatment a year ago and reports only in the last few months that he's been drinking socially more. He says this is not every day or excessive, and he's responsible to get an Uber home if he needs to. It's not clear to you that the agency knows about him drinking. So I'm going to open the next poll here. If you all can go there. Everybody can see that. Next poll is: a pregnant mother has an open child protective services case with 3-year-old at home. On the advice of her doctor, she initiates medication for opioid use disorder. The judge in her case has directed her to cease medication. What concerns does the judge's order raise? None. Judges can order what they like. None. It seems reasonable that medication for opioid use disorder would be harmful to a pregnant woman and her baby. Or there are civil rights and social work concerns. See the votes coming in fast. Right, we got about half the votes in, and the group says there are civil rights and social work concerns. Dr. Young?
Yeah, I think folks can tell that our polls and our vignettes got a little bit out of order, because the vignette that we just talked about was the father that was on medication-assisted treatment. And one of the questions is, how long is someone to be on medication-assisted treatment? And let me just respond to that, because I think some of the other pregnancy ones we've covered. But the vignette that Scott read about the client that's been on medication-assisted treatment and is drinking, and what's the appropriate length of time. So I have to, kind of compare this as, what would we do in a situation for any other kind of chronic medical condition, chronic disease? Those kinds of decisions are healthcare decisions rather than legal constructs. We wouldn't prescribe or say, what dose should a person with needing insulin with diabetes has. We wouldn't think about that in terms of a dose for hypertension, other chronic medical conditions that are not uncommon. So judges, social workers, and attorneys wouldn't prescribe those. And that's sort of the answer back on, what should judges and attorneys do about the length of time, or we do hear this. We get questions in about making recommendations about doses for either methadone or buprenorphine. And again, those are medical decisions. So Scott, I think that we're back on track in our questions, our polls, and the presentation of the vignettes. And I think we're turning things back to see if there's some questions or things in the chat, and then get into the content on the civil rights protections.
Yeah, we wanted to pause right here just to invite people to put questions in the questions box. I think in there, some of you that have been at this conference for a little while will know you can upvote things, and that'll help consolidate what are the real burning questions. And we're going to try to get to them as we go. At the end, we're going to invite you to send your emails to me if there's questions we don't get to, because we can do follow-up after this. But if you have questions right now, we will be taking them as they roll through. But otherwise, I'm going to switch back to Carla and Ann for the other slides.
I'm back. Okay, so if there aren't any other questions, hopefully this presentation, this portion of the presentation will answer some of the questions or raise some additional questions that you may have. And so as the title indicates, Ann and I will talk about federal disability rights protections for individuals in recovery from an opioid use disorder. And while it does say opioid use disorder, I think we can look at this more broadly and name it substance use disorders. Next slide. So I'll introduce myself in the event that you just joined. My name is Carla Carter, and I'm the Associate Deputy Director for Civil Rights with the Office for Civil Rights. Before we delve into the law, I offer for your consideration the Office for Civil Rights and the Department of Justice as a resource that can help address and respond to discrimination in the child welfare system. OCR and DOJ share jurisdiction over many of the entities that provide services and supports to parents and children involved in the child welfare system. But we also work together very closely to respond to allegations of discrimination more broadly, not just in child welfare, but in many health and human services contexts. With respect to child welfare, recently OCR and the Department of Justice entered into an agreement with the state of Massachusetts to address concerns, and actually we issued a violation that the state agency violated the rights of a parent with a developmental disability in that they denied her opportunities to reunify with her child of her infant for a long period of time. And this was the first time that OCR and DOJ entered into a settlement to address disability discrimination involving the rights of parents with intellectual disabilities. And it's the fourth agreement that the Office for Civil Rights has entered into with state agencies to safeguard the rights of parents and prospective parents with disability. And so this slide really just kind of explains our respective roles and responsibilities. Next. So I think it's important that we acknowledge at the outset that a lot of the language that we use really appears in laws that were enacted 45 years ago. And it's not reflective of person-first language that we more frequently hear today. And so we acknowledge and recognize that this language can be offensive and can be stigmatizing for people with substance use and alcohol use disorders. Next. Disability discrimination in the child welfare system. OCR and DOJ have received numerous complaints of discrimination against parents and children with disabilities in the child welfare system. Our investigations reveal that state child welfare entities, as well as private agencies, vary in the extent to which they've adopted appropriate policies and procedures to prevent discrimination, and that parents and children with disabilities encounter a wide range of barriers when accessing the services that they need. Next. So this is kind of our roadmap for the next couple of minutes. So we will talk about who is protected by these laws, what covered entities have non-discrimination requirements or who are required to comply with the laws, and what covered program services and activities should you think about if your clients encounter these problems. We'll also spend a little bit of time looking at the federal disability rights laws, and then who is a qualified individual with a disability. Next. So who is protected from discrimination in the child welfare system? A lot of people. Children and their parents, aunts and uncles, legal guardians, foster parents. Federal disability rights laws protect a wide range of individuals with disabilities from discrimination, and they also protect companions of individuals involved in the child welfare system when the companion is an appropriate person for which the agency should communicate. Next. What covered entities must comply with these laws? Well, if you look at the list, probably many of these you're familiar with: state child welfare agencies, county agencies, courts. But did you know that private and nonprofit agencies, child placement agencies, daycare providers, and the other agencies that are listed also have these obligations? Well, many of them are subject to non-discrimination requirements because they either directly or indirectly receive federal financial assistance from HHS. And when I talk about federal financial assistance, because I've learned over a period of time that at the federal government, we throw those terms around all the time. So I'll tell you the funding that I'm talking about. So these are the Title 4E and 4B funds, entities that accept Medicaid or CHIP. We know that TANF is used a lot of times to support child welfare, and state court improvement program funding. And so those are the kind of recipients that we're thinking about. And then state and local governments that administer child welfare agencies are also covered under the ADA, regardless of whether or not they are also recipients of federal financial assistance. So here's an example. A parenting skill provider may be subject to non-discrimination requirements because it accepts Medicaid as a payment. And so that's something for you to think about in, to the extent that maybe someone that you represent runs into a barrier with one of those kind of services. Next. Covered child welfare programs, services, and activities. Pretty much many of the activities that your clients may be involved in or services that they receive are covered. And so that includes child protective services investigations, safety and risk assessments, case planning, reunification opportunities, visitation. It's an entire list here, and also some aspects of court proceedings. Next slide. And so we will spend the latter part of this presentation focusing on Section 504 of the Rehabilitation Act of 1973 and Title II of the Americans with Disabilities Act of 1990. So federal civil rights laws really complement Title IV-E agencies' obligations to make reasonable efforts, because it requires that the 4E agency make an individualized determination about a parent with a disability that is based on reliable facts and objective evidence. So here's an example. Child welfare agencies use a wide variety of tools to assess for current and future harm to a child. And in this context, the federal disability rights laws would prohibit the removal of a child from a parent with a disability based on the stereotypical belief, unsupported by an individualized assessment, that some parents with disabilities are unable to care for their children. And so that's pretty powerful there. And we know that that happens more often than not. So I invite you to spend a little bit more time thinking about whether or not your clients have been assessed based on actual facts and objective evidence about their disability. Next. Oh, I see Richard Pittman said he'd like to invite me to come to Louisiana. I'll go. Okay. So here's Section 504 of the Rehabilitation Act. It says no otherwise qualified individual with a disability in the United States shall solely by reason of his or her disability be excluded from the participation in, denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance, or any program or activity conducted by an executive agency. And so the Section 504, just to pause for 1 second, Scott, Section 504 really focuses on who is receiving funds and whether or not they have those obligations. Title II of the Americans with Disabilities Act is much broader in that it covers, it says no qualified individual with a disability shall by reason of such disability be excluded from participation in or be denied the benefits of services, programs, or activities of a public entity. So when we think about public entities, we think about state and local governments, or be subjected to discrimination by any such entity. And then Anne will, she may cover Title III of the ADA, which would reach some of those entities who are both recipients, but they're public accommodations as well. We'll go next. And so the regulatory provisions of Section 504 in the ADA really track the language of the laws very specifically. And so we see that individuals with disabilities must not be excluded from a program or activity or denied the benefits of a program or activity, afforded opportunities that are not equal to those opportunities afforded to others, and cannot be provided a service or activity that is not as effective as what is provided to others. And that's really important because I think, you know, you've seen in the work that you've done where, you know, parents with disabilities may receive services that are less than what would be provided to another parent without a disability is seeking also to be reunified with their children. Next. And so Section 504 also required that covered entities provide effective and meaningful access to their programs, benefits, or services. And so for some individuals, that may be providing appropriate auxiliary aids and services at no cost to the individual, or making reasonable modifications. And so here's an example. When a child welfare agency communicates with a parent who is deaf, the agency must provide appropriate auxiliary aids and services to the parent to ensure effective communication. And it should be at no cost to the parent. And so in this section, we'll actually look a little bit more at the definition of disability, which is the same under Section 504 and the ADA. So disability is defined as a physical or mental impairment that substantially limits one or more major life activities of an individual. It also includes individuals' conditions where there is a record of an impairment or the person is regarded as having such an impairment. Under the ADA amendments, the ADA amendment of 2008 made significant changes to the meaning and the interpretation of the ADA definition of disability. And so it provides a much broader coverage and it doesn't require an extensive analysis. So physical or mental impairments, here's a nice list. And as you can see at the very bottom, there are drug addiction and alcoholism. And again, these are terms that are used specifically in the laws, and it's not intended to be offensive. Next. So what is a major life activity? Well, that's the ability to care for oneself, perform manual tasks, breathing, standing, lifting, speaking, learning, concentrating, eating, or sleeping. And often when I do these presentations, you know, I ask folks in the room, how many people have a disability? And, you know, there are some that are comfortable and will raise their hand and others that don't. But I'm a person with a disability in that I have several breathing conditions that limit my ability to do certain things. And so, you know, including breathing, especially during the allergy season, but during others, you know, I have arthritis in my legs. And so, you know, that, you know, impacts my ability to walk. You know, it also covers operations of major bodily functions, and including functions of the immune system, normal self-growth, digestive and bowel, neurological, endocrine, and reproductive functions. Again, this is not an exclusive list, but these are some examples of things that we think would resonate with folks. So disability laws, rights laws, prohibit the consideration of ameliorative effects of mitigating measures such as medication, hearing aids, medical supplies, and equipment when determining whether or not a person's impairment substantially limits a major life activity. And so an example would be a person with hearing loss would be substantially limited in the major life activity of hearing, even though the hearing loss may be mitigated with a hearing aid. So I'm going to turn this over to Anne, who will provide some additional information.
Thank you, Carla. As Carla mentioned, I'm in the Civil Rights Division at the Department of Justice, so we work quite closely with the Office for Civil Rights. But relevant to this session, I'm in the Disability Rights section, which enforces the ADA in a number of contexts. And two areas where we've been active along with OCR is in allegations of discrimination in the child welfare system across a range of disabilities. And separate but related, we've been doing work at DOJ related to discrimination against people with opioid use disorder in a range of contexts, including employment, public accommodations, which are private businesses, and we've reached settlement agreements where entities have excluded people from participation in programs or employment based on recovery from opioid use disorder. So I'm going to talk a little bit about the additional requirements of ADA and 504. And as Carla mentioned, the definition of disability is the same in both laws. And I will just say that generally speaking, substantively, the laws are very, very similar. You can almost assume that, that the same requirements apply in Title II of the ADA and Section 504. So Carla talked about the definition and emphasized that it's broad and it's construed broadly under the law in favor of coverage. But in order to come into the protections of the law, the individual with a disability has to be qualified for the program at issue. And so if you go to the next slide, Scott, I'll tell everyone what that means. So the law defines a qualified individual with a disability as an individual who, with or without reasonable modifications to rules, policies, or practices, the removal of architectural, communication, or transportation barriers, or the provision of auxiliary aids and services, meets the essential eligibility requirements for the receipt of services or the participation in programs or activities provided by a covered entity. Now that's a mouthful, so I'll break it down. But basically, the first prong, the first bullet there, is intended to capture that if a person with a disability needs an accommodation in order to participate, that does not render them unqualified or ineligible for a program. So for example, if a public entity offers a class and a person who is deaf needs an American Sign Language interpreter to understand the instructor, that does not render that person ineligible for the class. And that entity would have an obligation to provide effective communication. Vice versa, if a public entity had a program that had as a criteria that you can't participate if you have a recent criminal conviction, if a person with a disability applied and was excluded based on a recent criminal conviction, they would not have coverage under the ADA or 504 if they were excluded on that basis. So the second prong here talks about essential eligibility requirements. This captures the principle that entities can't use requirements or criteria that screen out people with disabilities or have the effect of screening out people with disabilities unless those criteria are essential to the program. So for example, if a foster care program had a blanket policy that you can't be a foster parent if you have a physical disability, that would likely be an impermissible, that would not be an essential criteria, and it would be impermissible under the ADA and 504. So if you go to the next slide, Scott. Carla touched on reasonable modifications, and this is one of the requirements that public entities must provide under the ADA and 504. Entities must provide modifications that are necessary to avoid discrimination, or put another way, necessary to ensure that the opportunities they provide to people with disabilities are equal to those provided to people with disabilities. So examples in the child welfare context might include increased frequency of parent-child visits, in-home parenting skills training, if the entity usually does that training outside of the home. Certain people with disabilities may need it in a natural environment in their home, and that could be a reasonable modification. They also, another example could be note takers or other aids or services for people with learning disabilities. So these are just some examples. I will note that what is and isn't a reasonable modification is highly fact specific. And so it will depend on the circumstances of the case and the abilities of the entity to provide them. So Scott, if you go to the next slide, I'm going to talk about two defenses that entities have when it comes to non-discrimination and providing reasonable modifications. Both public and private entities do not have to do anything that would result in a fundamental alteration in the nature of the program or service, or would be an undue financial or administrative burden. And so this comes up oftentimes, entities raise it. But basically a fundamental alteration is a change that is so significant that it alters the essential nature of the service, program, or activity. And when an entity raises this issue, they have the burden of proof to establish that something would be a fundamental alteration or an undue burden. And if a particular request from a person with a disability would amount to a fundamental alteration, the entity nonetheless has an obligation to provide accommodations that would enable some participation and would not amount to a fundamental alteration. And then the next slide, actually, if you go to the next one, Scott, I was going to talk about direct threat, which is relevant in the child welfare context and a lot of other contexts. When an entity excludes an individual with a disability from programs, they can do so if the individual poses a direct threat to the health or safety of others. And the law defines a direct threat as a significant risk to the health or safety of others that cannot be eliminated by a modification of policies, practices, or procedures, or by the provision of auxiliary aids and services. So if there's something or a service that can mitigate the risk, that should be provided and considered before deeming someone a direct threat. This is also, when it comes to direct threat, it's also important to remember that a determination of direct threat cannot be made on assumptions or stereotypes about people with disabilities, including people with substance use disorder. It has to be determined on an individualized assessment of that person based on reasonable judgment that relies on current medical knowledge or on the best available objective. And the analysis ascertains the nature, duration, and severity of the risk. In the child welfare context, what is the nature of the risk to the child, the probability that injury will occur, and whether there are accommodations that could mitigate that risk. So using this analysis, generalized assumptions and stereotypes cannot be used, but in some circumstances, an individual with a disability may pose a direct threat and may not be qualified for purposes of child placement. So if you go next, I'm gonna talk about the ADA and 504 specifically in the context of alcohol use disorder and substance use disorder. So Section 504 and the ADA specifically define alcohol addiction as an impairment under the laws. And to amount to a disability, it must be an impairment that substantially limits a major life activity. So if you go to the next slide, Scott, in the context of substance use disorder, the laws also define addiction to drugs, and that's the term that they use in the laws, as an impairment covered by the disability rights laws. Whether it amounts to a disability on the next slide will depend on whether the substance use disorder substantially limits a major life activity, or whether the person has a record of substance use disorder. So that could be somebody who's in recovery, but they have a record in prior medical records or employment records or even military records of having an addiction to drugs. And then sometimes we see that individuals may be regarded as having substance use disorders when they don't, and such individuals are still protected under the law. So generally speaking, people with opioid use disorder typically have a disability because they have a drug addiction that substantially limits their major life activities. The condition occurs when the recurrent use of drugs causes impairment, including health problems and the failure to meet responsibilities at home or at work. And we've seen some courts have determined that social interactions and parenting as major life activities. So where a condition affects the ability to parent, courts have found them persons with disabilities under the ADA and 504. There's a significant exclusion to this in the statutes, which I'll get to on the next slide. So the ADA and Section 504 do not cover individuals who are currently engaged in the illegal use of drugs when the entity acts on that basis. The illegal use of drugs means the use of drugs, the possession or distribution of which is illegal under the Controlled Substances Act. So that could include, using a controlled substance that's not prescribed to you, or misusing a controlled substance that is prescribed to you, or obtaining, using a drug that was obtained with a false prescription. And one issue that comes up a lot with this exception is, what does current engagement mean, current use of drugs? And there's a wide variety of court interpretations on this. So if you're dealing with this issue, it's important to look at the law in your circuit. We've seen some courts take the approach of, it has to have been several weeks or several months ago, the drug use, or some have taken the approach of as recent as 30 days, does not give rise to current drug use. So it's really a fact-based inquiry, and the main questions seem to be, how long ago was the drug use, and is there evidence that the drug use remains a problem? So just an example in the child welfare context, if a newborn was exhibiting withdrawal symptoms relating to prenatal exposure to cocaine and is removed from the mother based on the mother's recent use of cocaine, the mother under those circumstances may not be covered under the ADA or 504. Go ahead, Scott.
And we did have a question related to this, that about when people are prescribed medical marijuana.
So marijuana is a question we get a lot, actually, in a lot of different contexts, because even though marijuana use is legal to varying degrees under state law, some it's totally legal, some it's legal for medical use only. Under federal law, it is not legal under either. So technically, under the law, it would be considered illegal use because federal law does not recognize it like state laws do. So that is a wrinkle. Alcohol use, it's not considered illegal, so it wouldn't have the same analysis either. Someone with an alcohol use disorder would still be covered, technically under the law, because it's not, if they're still using, because it's not you don't have this issue of illegal use of drugs. Now, there could be something about the alcohol use disorder that renders a parent a direct threat, which would be a different analysis. So this gets us into the important point that Dr. Young and Scott talked about earlier, that under the law, under the ADA and 504, illegal use of drugs does not include the use of a drug taken under supervision by a licensed healthcare professional, or other uses authorized by the Controlled Substances Act or other provisions of federal law. So if a parent is prescribed methadone to treat an opioid use disorder and is not otherwise engaging in the illegal use of drugs, then they are protected under the ADA and 504. Additionally, an individual, the law does protect individuals who have successfully completed a supervised drug rehabilitation program and is no longer engaging in illegal use of drugs, or has otherwise been rehabilitated successfully and is no longer engaging. They also protect people participating in a supervised drug rehab program and are no longer engaging, or, as I said earlier, individuals who are incorrectly regarded as engaging in illegal drug use. An example in the child welfare context, if a father seeking reunification with his children has successfully completed a drug substance use disorder treatment program and is no longer engaging in the illegal use of drugs, that father would be protected under the ADA and Section 504 and would have those be considered a person with a disability. I've seen drug testing come up a lot in the chat, and I'll address it on the next, if you go 2 slides ahead, actually, Scott. The federal disability rights laws do not prohibit a covered entity from conducting drug testing. So covered entities can conduct drug tests of participants in their program. There is one exception to illegal drug use that I'll get to on the next slide. Covered entities cannot deny health services or drug rehabilitation services to an individual based on that individual's current illegal use of drugs, if they're otherwise entitled to such services. So for instance, if someone using illegal drugs, hopefully this doesn't happen, but if they presented themselves at an emergency care center and needed emergency medical care, they could not be denied services based on illegal drug use. Drug treatment programs can, though, require abstinence as a condition of participation, and they can terminate a participant if they continue to use illegally when abstinence is a requirement. So let me get to the next slide to talk about medication for opioid use disorder and substance use disorder. I know that, what we've talked about so far is that the definition of disability is very broad, and it is in this context as well, with the important exception that it's people engaging in the current illegal use of drugs are not protected. But it is not an illegal use of drugs to take medication for opioid use disorder or substance use disorder under the supervision of a licensed healthcare professional. So if you go to the next slide, if you're seeing this fact pattern, you would first consider whether the person receiving medication for substance use disorder is an individual with a disability. Is it a qualified person with a disability? Is that person qualified for the program? And I should note here that for child removal purposes and reunification, a parent who is in the child welfare system for that reason and is seeking reunification would likely be qualified because they've been referred for child welfare services. And then you would analyze whether the person receiving medication for that substance use disorder is engaged in the illegal use of drugs. And if they are, they're likely not protected. If they are not, then they do come within the law's protections, subject to defenses. So I'm just going to give a few examples of prohibited conduct that would come up in this context. If a court has a policy of denying visitation because a parent receives medication for an opioid use disorder, that would likely violate the ADA if they're not doing individualized assessment. where if a child welfare agency requires that a parent step down their receipt or discontinue the receipt of medication as a condition of reunification, that would also be problematic under Section 504 in the ADA. And similarly, if a child welfare agency removes a child from a parent receiving medication for substance use disorder based on unfounded assumptions related to risk or stereotypes about the illegal use of drugs, that would also be problematic, because here we're talking about that lack of an individualized assessment around the ability to parent and direct threat, and the prohibition on stereotypes and assumptions. So I'm going to turn it back over to Carla, who's going to talk about a recent agreement.
Okay, hi, and everyone. So I believe that we provided links to some of this information, but in 2019, the Office for Civil Rights received a complaint from an aunt and uncle who sought to obtain custody of a niece and nephew that were placed in foster care. And they went through the home study process, and despite receiving a favorable home study, the Child Welfare Agency determined that they were not an appropriate resource for the kids because the uncle had a history of taking prescribed Suboxone as part of his MAT program. And the agency denied to give them an opportunity to even serve as a kinship placement based on that very reason. And so OCR conducted its investigation and interviewed folks. And, you know, as we learned today, folks, a lot of the social workers really believed that the uncle was substituting, was using MAT as a substitute for engaging in the illegal use of drugs. And despite over a period of time that the uncle had stepped down and actually was no longer receiving the medication, it was his history of having received the medication that still put him in a state where they were not willing to allow him and his wife to care for the children. And what was even, I think, more interesting is that the aunt would have been the primary caregiver for the child, and the uncle, you know, worked outside of the home. And these were small children, and the aunt and uncle had their own children in the home. And so clearly the agency was applying different standards. And actually someone during an interview said, it's one thing for a person to receive MAT when they're caring for their own children as a foster parent or a kinship resource. You know, we expect a higher standard of care. And so we had a lot of conversations with the Child Welfare Agency, and we learned that, as is often the case, that a lot of the folks who are working in this field have not received training on what federal civil rights laws require. And if they haven't had personal interactions, either through personal experiences or having worked with people with disabilities, they just made judgment calls based upon what their own understanding of a person's disability was. And so we certainly worked with West Virginia, and we're continuing to work with them to get them to implement policies and procedures and practices that protect the rights of people with disabilities, including individuals in recovery from a substance use disorder. And West Virginia had been waiting quite patiently for this technical assistance package to come into existence. And so we will make that available to them, as well as anyone else that would be interested in receiving this. And so, since I've teed it up, Scott, next slide. So here's the technical assistance package. As you might have guessed, OCR and the National Center have worked very closely to develop a technical assistance package, which we knew was very much needed for the field. And so, you know, and part of this was a recognition that there just isn't civil rights training in the context of child welfare out in the universe. And I think we kind of figured out, Ann and I and others who work together very closely, that we're going to have to be that resource. And it can't be on an ad hoc basis. It just needs to get some materials out there. And so over a year, we've worked with the National Center on Substance Abuse and Child Welfare to produce this 5-part video and webinar series. And it informs individuals about the application of federal disability rights laws to child welfare. It discusses protections that apply to individuals in recovery. It provides a really good overview of what is medication-assisted treatment, and it addresses common misconceptions about medication-assisted treatment as a treatment approach. Next slide. And so, again, these are some of the concepts that are covered throughout the technical assistance package. Next. So one of the great things of working and partnering with the National Center is that they were able to use their resources to create materials that are specific to the child welfare system. And so instead of us always talking about what it is, we actually, they were able to put together a mock case staffing showing the interaction between a social worker and a supervisor. And the discussion surrounds a parent who's receiving medication-assisted treatment. It addresses misconceptions that are voiced by the caseworker. And then also it talks about, you know, how the parent may be protected by federal disability rights laws. Next. And so again, these are just kind of some images from that discussion. Next. And then, you know, Nancy and her team took it one step further, which is what I loved about working with them. It's like, it's not enough to say, what is the discussion between the caseworker and the supervisor? How about we show what that interaction would be in court? And so here you see the actors that would be in court, and they actually have a discussion about, you know, what are they going to do when the mom requests visitation for her child, for her children. Next. And the not as interesting aspect of this package is a 2-part webinar presented by the Office for Civil Rights, which gives you a deep dive into the protections for individuals in recovery from an opioid use disorder. And it's broken up in 2 parts. So part 1 is just how does the ADA in Section 504 apply to child welfare more broadly. So these are concepts that you can apply and child welfare agencies can apply to all parents with disabilities, as well as children with disabilities in the child welfare system. And then the second webinar focuses really on the protections for individuals in recovery from an opioid use disorder. So those materials will be, I think in the chat, we reference those materials.
Great. Thank you, Carla. And right before I turn it over to Christina, would invite the rest of the folks on the panel to take a look at the questions or in the chat, because we are amazingly almost perfectly on time, down to a minute or so. We'll probably have some time to answer those. But Christina, take it away.
Thanks, Scott. Yes, please do keep the questions coming in, and my fellow co-panelists can answer them in the chat, or we will have a couple minutes after I conclude my brief slides. We just wanted to make sure, as you're observing all this information on medication-assisted treatment and federal civil rights options, and you have Carla and Ann's emails now, so I'm sure we'll make use of that. Keep in mind the federal and state child welfare advocacy tools that you likely know, but can see how they come together and how they all sort of interact both on your individual case level and as a basis or a need of system reform. So Scott, if you can move to the next slide, we can start with some federal laws and policies. Recent developments at the federal level have provided some additional guidance from the Federal Department of Health and Human Services and others, and opportunities for working with families in these cases. So hopefully you have heard at least a bit about the Family First Prevention Services Act that will allow state agencies to draw down federal funds for prevention services in the areas of substance use treatment, parenting skills, and mental health treatment. They have to be approved by a federal unit and then made available in your jurisdiction for the states to start drawing down those dollars. But we are hoping that that will happen increasingly if it's not happening already in your jurisdiction. There is one medication-assisted treatment that's been approved on the list so far, a methadone maintenance therapy. So as soon as your state officially starts the prevention services options and drawing down federal funds for that, which just hopefully is complementing a larger array of prevention services that they have in place or that they're putting in place. That's certainly something to be advocating for as a prevention service before a child is removed from the home. And so that's something to be aware of and keep on your radar. States can also draw down funding for a child's placement with a parent in a family-based substance use treatment setting under the Family First Act. We haven't heard of that catching too much wind yet in the states. There are a number of these settings in jurisdictions already, but it's an important element to be raising with your Family First implementation team, with agency folks who you work with, administrators, others, that states can draw down federal 4E funds for a child's placement with a parent in this residential setting. For a parent who is interested in treatment in that setting. That's not something, those settings have been available before, but the state agencies couldn't draw down federal funds for them. They can now. So ideally, if the agency has to start a formal case or chooses to start a formal case, this is an option to keep the child with the parent in those types of settings. They can also continue providing reunification services under Family First. Is more of a timeline issue. It's a different funding stream, but there are federal dollars to provide services to families after the child has been returned to the parent's care in the parent's home for up to 15 months after the period when the child goes home. That's a change in timeline. That's just important to know. The agency can provide services for an extended period versus earlier in the past few years, if they feel they need to and aren't ready to close the case for the various reasons that agencies sometimes aren't, or the court isn't. So they can access federal dollars for that too, which hopefully makes it a bit more palatable. CAPTA is the federal law that generally governs agency practice when an infant is born affected by substance abuse or withdrawal symptoms, or the fetal alcohol spectrum disorders. And recent changes highlight the need to create plans of safe care, not just for that infant, but also for affected family members, i.e. the mother or father or other caregivers. There are resources where you can get more details on that, but it's important just to be aware of what the agency's policy is. And so you can anticipate how it will play out and anticipate where your avenues for advocacy may be if they don't have plans of safe care for both infants and affected family members. This is an area where you can push for the agency to offer more and to be more supportive. Broadly, it can be more advocacy at the system level for an approach that is supportive of parents and services, provide services for them rather than penalizing them in those situations. You are familiar with the items on the next slide, I suspect. Reasonable efforts. the agency needs to make reasonable efforts. I take a look at these resources we've included here as ways of identifying and arguing what are reasonable efforts when a parent has a substance use disorder or versus does not. There are some starting points there. I won't go into the details, but we hope that those will be useful to you in your arguments in individual cases as well as more broadly. And finally, just some state laws and policies. Determine on the next slide what they are, compare with what other states have, and see if you can use those as an avenue for improving your local laws, court policies, agency policies, and start considering where you need relevant case law and to start appeals and making appeals in certain cases. That is a rushed version, but hopefully a reminder to you that there are resources and advocacy tools at your local levels, at your state levels, that can be combined with what you're learning from the federal civil rights levels and then more information on medication-assisted treatment. Now I'll turn it back to you, Scott, so we hopefully can answer a couple of questions and highlight some resources we have.
Yeah, if there's anything you want to say, Carla or Nancy, about the next two slides, and I don't know if there's any questions you wanted to try to answer in our last minute here.
Well, I just would really invite everyone to visit the National Center on Substance Abuse and Child Welfare website. You saw that Jennifer Sangira, who is a senior program associate with us, and I've been trying to keep up and post some links to some resources in the chat and in the question box. So you see we've got a lot of stuff on a lot of questions, and so we'd love to have you reach out to us, go on the website, send us an email, let us know what your questions are and how we might be helpful in your jurisdictions.
Hi, and this is Carla. Just a reminder, just piggybacking off of Nancy's comments, that these are free resources that are available to you, to the state agencies, if there are local bar associations. Ann and I, we try to hit all the national conferences, but we know that we're not getting to everyone, but we are, especially we're in a virtual environment these days. It's a lot easier for us to put on our clothes, at least, I'm not going to stand up, but, I'm half dressed. But it's a lot easier for us to present and field questions. Matter of fact, next week, I'll be talking with some folks with the Louisiana Court Improvement on Title VI and race discrimination. And so that's just going to be a small group discussion. And I know that Ian and others have had these discussions as well. So feel free to reach out to us, visit our websites. OCR has a child welfare specific page where there are a lot of resources. We recently re-upped it. It's not as pretty as a lot of other federal agencies' websites, but it's the best that we can do on a shoestring budget. But please know that we are here as a resource, and over the next year or so, look out for some additional materials that will be posted, because there is an executive order on strengthening the child welfare system, which requires that the federal government focus more on child welfare, particularly the rights of children and parents and prospective parents with disabilities. So we expect to do some additional work in this area. So thank you very much.
So I see we've gone over a few minutes, but there's still a lot of you here. So thank you all for coming, and I'd like to thank the panelists for sharing. And we got to some of the questions, but we plan to look through the questions and send responses to whoever was interested. So if you want to let me know if you'd like to see the responses to the questions, if you go to the people, I think you can click on my name, Scott Trowbridge, and just send me your email in there and we'll collect those. We won't use it for anything else except for responding to the questions we got today we didn't get to. But thank you all for attending.
Thank you. Bye.